When it comes to your legacy plan, do you clearly understand the differences between a trust and a will? If not, let's talk about it. I'm Eleanor Curry, your favorite business law and real estate attorney, and this is our Wealth and Legacy series where every week we're diving into ensuring you understand how to create your legacy through a wealth plan that incorporates what you're doing now in life and what happens to you in the legacy and the generations behind you. And today we are trying to give some clarity to the differences between a will and a trust. And because those differences can be vast, we're going to break this down into a couple of different sections, and each one talking about three of the major differences between a will and a trust. Because for a lot of people, they think, hey, they do the same things. If something happens to me, I want my assets to be handled in a certain way. I want them to go to my kids or my grandkids or my loved ones or my spouse. And we want to talk about the differences between these two structures because they can be important and they can have some really long-lasting impact on your intended beneficiaries depending on which one you choose. So let's start first and foremost with what happens if something happens to you, right? And often we think, our brain thinks that means death, but in reality, that can mean incapacitation. People are living longer, and that incapacitation could be sudden, or it could be something more gradual, like having dementia or Alzheimer's, which is not uncommon when it comes to people as they get older. So let's talk about the differences with a will and a trust in the case that it's not death, it's incapacitation. Well, first and foremost, wills do not address it. They are a set of documents that are meant to govern what happens at your death. And a trust is a little bit different because if you have selected a living trust, you are the first beneficiary. And you are going to be the recipient, or the funds will be directed towards you and your care in case of incapacitation. That may be short term. You just need someone to make a medical decision while you're in surgery, or you are temporarily incapacitated. It could cover that, but it could also cover much longer durations of incapacitation. So first things first, what happens if you're not addressing death? A trust you can put guidelines to what you want to happen to your assets, to your money, to your business in case of incapacitation. With a trust, you cannot do so with a will. So step one, that's a major difference. And second, the first thing people think about is, okay, I do want to have some direction as far as what happens to my things if something does happen to me, or in the case of my death. So yes, a will does address that, as does a trust. However, they address it a little bit differently. Even if you put a will together, and even if you put in an independent administrator, or the person you intend to execute your wishes that you put in your will, it still goes through a process of probate. And this is a legal process where you will present the will to the court. The court will, if there's an independent administrator suggested or appointed, either appoint an independent or dependent administrator, and then you'll go through the checklist and the process of probate. That is much different than the process in a trust. If you choose a living trust, the trust actually funds or directs assets to the trust in your lifetime. So that means as soon as something happens to you, the trust becomes irrevocable, and the directions you put in place and all the assets that are covered under the trust automatically can begin to operate under the new person in charge. And that may be the beneficiary, or it may be whoever you've put in charge as a trustee. So that change is automatic because as you funded it in life, you've changed the ownership of those assets to the trust itself. So whether you are in charge as the beneficiary and the executor, or the next executor in line takes control, they're going to follow your instructions with the things that are already found and funded within the trust. So that is another big and major difference. And so last but not least, when it comes to the difference between a trust and a will and how it actually operates, is anonymity. That's a super big question. People want to know what the privacy policies are for wills or trusts. And I will tell you that wills are public. Like once you take a will to probate, like many court filings, is public information. People can go read, they can understand who the beneficiaries are. If you didn't know you were a beneficiary under a will, you can certainly go find out. And you have the right to intercede in that court action if you feel as if your interests aren't being, as a beneficiary, aren't being improperly protected. That's much different than a trust. You're going to set trust instructions, you're going to have trust documents. However, these documents are not publicly filed. So there is a level of anonymity, of privacy when it comes to how a trust is formed, who is the executor of the trust, and also who the beneficiaries are and the assets that are held within the trust. So privacy and anonymity is a benefit of having a living trust, not so much for having a will. So we'll keep tackling some of the differences and key differentials between a will and trust. But make sure if you have questions, you want more information, you reach out to us.